Hello, this is Yoshi. Thank you for watching this video. So today, I want to tell you Chinese UTT model application. Do you know the UT model in China? That's not patent, but very similar system to protect an idea. So that's not UTT patent application in the United States. We call sometimes the UTT model as small patents or petty patent. So in my country, Japan, Japan has the UTT model application as well, but people in Japan do not use the system so many. Please watch the UTT model application amounts per year in Japan. Likely China. Japanese UTT model does not need a substantive examination by JPO, Japanese Patent and Trademark Office examiners. I think people here in Japan do not like unstable property rights, since JPO may judge the UTT model rights as unenforceable rights later. Especially JPO examiners are one of the world tough examiners, and people dislike fighting against examiners during the dispute against their infringers. On the other hand, people in China, so they had filed 2,259,765 UTT model application in 2019, just 1 year. In the same timing, Japanese UTT model application were just 3,693. Thus, 2019 amount of Chinese UTT model application was 432% or more than Japanese one. One of the big reasons will be its rejection rate in China. After granted of the UTT model, most of the Japanese do not know this gap between Japan and China about the UTT model system. We just think Chinese UTT model is not so strong like a Japanese UTT model. Chinese examiners must be tough, and then they have a very, very tall order of patentability or UTT models as well. However, the reality is not true. Chinese UTT model is very, very popular since its application cost is less than half of patent filing. Almost half, right? Less than half sometimes. I want to inform you this benefit and also tell you the detail today. I invite Mr. Alonso here. He is Chinese attorney.
Hi, everyone. My name is Alan. I'm an IP counsel under China IP jurisdiction, and our firm is Japan IP Law. Founded in 1988, our firm has gradually developed from a small-size patent legal service provider into a full-service IP law firm specializing in broader fields of IP filing, prosecution, and litigation. Over the span of 30 years, the firm has expanded to a total of 10 offices in Beijing, Changsha, and Guangdong, staffed with a team of hundreds of professionals covering all technical backgrounds. And as I said, and I am an IP counsel in the International Department of Japan. I serve as a coordinator, a mediator, and licensed to help domestic and overseas clients with any kinds of IP matters in China. And I will take today's chance to share some info about the Chinese utility model application. Hope all of you will find today's speech helpful at some level. So let's begin. As you can see in this first slide of my PowerPoint, my whole speech will follow this outline. What I will share today are patent types in China and their flows from application to the extinction of the rights, the typical timeline for utility model, the advantages and disadvantages, the same-day application for an invention pattern and a utility model, and the technical evaluation report. Let's start with the first part. There are 3 different protection methods in China patent law. Each of them has a different duration. One law covers everything in China, while there were different laws in Japan. I know that. Regarding the inventions, the duration is 20 years. The object of protection is the invention of products and method. Both formality examination and substantive examination are conducted before registration. Depending on the inventions, it will take 2 to 3 years to get granted. Next, regarding the utility model, the protection duration is 10 years. The object of protection is the structure of things. Only formality examination is conducted. Generally, it will take about 6 to 10 months for the registration. And regarding the design, the duration will be 15 years. The object of protection is product design. The method of judgment is the design of the shape or the pattern or both. Generally, it will take about 4 to 6 months for the registration. As you can see, utility model and design don't require substantive examination in China, so the registration process will be much faster than that of invention patent. Next slide is about the flow from filing the application of a utility model to the extinction of the right. After filing an application for a utility model, a formality examination will be conducted for registration, but without a substantive one. During the examination, the invention step is not taken into consideration. After the decision of the registration, the contents of the utility model will be open to the public, so everyone can see it. The applicant, after that, shall pay the registration fee. The utility model rights will be extinguished 10 years after the application. This survival period cannot be extended at all. Here we come to the advantages and disadvantages. The advantages, first of all, as there is no substantive examination, you can get your rights very quickly. It's also important to know the cost of acquiring utility model is lower than invention patent. I will explain more about this in the next slide. Cons has 2 sides, of course. The disadvantage is that it has a limited range of protection. The utility model covers only the invention of products, but not the invention of methods. And since it doesn't require a substantive examination, the rights tend to be relatively unstable when comparing to the invention pattern. And of course, I will dig deeper into this point later. So I just said the low cost is an advantages of the utility model. Let's compare the actual difference between invention, the utility model, and the design. These 3 tables showed the cost respectively. The cost of intellectual property is divided into 3 parts here in China. As you can see here, the official fee, the attorney fee, and of course, the third part, the translation fee from foreign language to Chinese. In addition to the application fee, the table includes the cost of claiming priority, which is necessary when applying to China based on the original application in Japan or in other countries. The administrative fee paid to the China Patent Office also varies depending on the length of the application. As you can see in the tables, additional charge of claims or page will be required if situation happen. As a typical example, let's think about a case when the claims is within 10 items and the specification includes drawing doesn't exceed 30 pages. So there will be no additional charge in these two parts. In the average case of an invention patent, assuming that the number of characters to be translated is 15,000 and the total cost will be $3,314 US. On the other hand, in the case of a utility model, assuming that the number of characters to be translated is 5,000, the total will be 1,500, about 1,500. Therefore, utility model require less than half the cost of inventional patent. And that's why I said at the beginning, it's more cost effective. In this slide, you can see an approach that is being actively used in China, filing an invention patent and a utility model patent on the same day. In other words, you will prepare two identical documents. One is for the patent application and the other one is for utility model application. One thing to keep in mind is that if you have a prior application in a foreign country, for example, in Japan, you need to go through the Paris Convention to work on this approach. Same-day application cannot be made from the International Patent Convention, aka PCT method. Let's see the method of the same-day application and how it benefits you. First, in China, many intend to monopolize their intellectual property rights as soon as possible. However, in the case of a patent, they have to wait a minimum of 2 to 5 years for the registration. Taking even 4 to 5 years is also common if the case is rather complicated. The brand periods of intellectual property rights hardly match with the ever-increasing business speed nowadays. Considering today's quick business, competitors possibly take control of the market during the brand period. The Chinese market has many competitors who are always watching each other's movements. Therefore, this approach is frequently used in China when protection is needed as soon as possible. Second, when the utility model in China is registered, you can retain it as a backup of the invention under examination. After all, in China, not all the patent applications end in success. At last, if the patent has been registered as well, the applicants can hold both the utility model and the patent. However, in that case, the protection scope of these two applications should be different, aka the claim set should be different. This is prevent duplicate registration, which is also stipulated by the law in other Asian countries, for example, Japan. Such amendments to the claim set are not so difficult for local Chinese patent attorney. We can also capable to do that.
I had mentioned that the patent right of the utility model might not be stable as there is no substantive examination when talking about the disadvantages of a utility model in the previous slide. So on this page, we will talk about the technical evaluation report. The purpose of the technical evaluation report is to confirm whether the registration of utility model and designs which were without examination are correct. If there is no way to confirm like this, no one knows whether the utility model registered without examination is a valid one or not. First, we need to know the examination body is the Chinese Patent Office, aka CNIPA. The patent who can request the Chinese Patent Office for the preparation of the technical evaluation report is the patentee or any of the interested party. Licensee or licensor if you need example of what are interested parties.
So let me explain the contents of the technical evaluation report with specific documents. The evaluation's contents of the report are mainly divided into three. The part enclosed in red is the validated evaluation, invalidated evaluation, which the rights cannot be maintained, or partial invalidated evaluation. The partial invalidated evaluations will list the maintenance is permitted or forbidden in each claim. In the case the report is positive, the utility model rights have no problem in its validated. In other words, you can force other companies to stop infringing the content. In case the report is negative, the utility model will be invalidated. Then the utility model rights cannot be utilized at all in the shown documents. All 5 claims items of the utility model rights got invalidated evaluations. At last, in case the partial invalidated evaluation is shown, you can only force other company to stop infringing the claim that has no problem in its validated instead of the whole utility model. Since multiple rights or claims can be stayed in one utility model's application, some claims may be validated, while some others may not. In China, before filing the utility model applications, your Chinese attorney will go through the whole filing document, so they will have a big picture of the estimated result if there is an evaluation in the future, which leads to a positive expectation to the patent owner. Therefore, utility model seems to be rarely used in Japan, but the number of application in China is about the same as that for invention patent. So how's the technical evaluation report used? The report has 3 rows. First, the judgment in the technical evaluation report is treated by the court and the patent office as evidence for the judgment and the trials in the proceeding for utility model infringement. Second, it can be used to apply for deletion of posting on the internet, which also known as filing the complaint on sales platform, Alibaba in China or Yahoo sales platform in Japan, for example. Third, it can be used to apply for custom registration. For example, if you dispute a utility model infringement in court, you will need to request a technical evaluation report. Through the report, a substantive trial is conducted to decide whether to maintain the rights or not. So that's all for my today's speech. If you have any other questions about the patent application or any kinds of IP issue in China, feel free to reach out by email or WeChat. So I will pass the round to Yoshi here.
Thank you. Thank you so much, Alan. That's so appreciated. And then
Thank you.
I'm so excited to know how, that's a powerful utility model in China. And then, yeah, it's a very, very, helpful for Japanese people, not only Japanese, and then the United States and Europe as well. So thank you. And if you have any questions and any other issues related to IP, please contact to Alan. So his QR code here. So please, take a picture and then send to him any question. Okay, thank you, Alan.
Thank you,
Thank
Yoshi.
you.